And so what the court is trying to do in this case is basically figure out how the effects test that we just covered from Calder can be applied in an internet scenario. So again, they're borrowing a test that's used for defamation cases and saying, you know, we don't currently have a test to evaluate when personal jurisdiction can be asserted in an internet scenario. So we think that this case from the defamation context would be a great test. So they're trying to figure out how to apply it in this situation. So the Pavlovich court gets some guidance from holdings in other cases, and essentially come up with this sliding scale analysis, which is what you will use as attorneys when you leave this beautiful law school. And so the court mentions using a sliding scale analysis for internet cases, I believe on page 120, fifth paragraph. And essentially what they say is at the end of one scale are situations where defendant clearly does business over the internet. So you've got these two extremes, sliding scale. So at one end is a situation where the defendant clearly does business over the internet, Amazon, right? If the defendant enters into contracts with residents of foreign jurisdictions, meaning outside their state, that involve the knowing repeated transmission of files over the internet, personal jurisdiction is proper. So I'm going to say that again because what this means is this is how you determine with a website or internet scenario whether or not a particular state has personal jurisdiction over that internet creator, meaning website creator. So again, if the defendant clearly does business over the internet and enters into contracts with residents of foreign jurisdictions that involve the knowing repeated transmission of files over the internet, personal jurisdiction is proper. So if you have a dating website where there's perhaps it's a transmission of files, you're uploading stuff, you're getting approval for stuff on Facebook, they're like, yeah, we approved your picture, no, we took your picture down. You know, if there's some type of monetary business that's being done, it's going to be considered proper to have personal jurisdiction in whatever state you're giving. But I'll give some more specific examples. So again, we know at one end of the scale is yes, the defendant clearly does business over the internet, all right, Amazon. At the other end of the sliding scale, the opposite end is where the defendant has only posted information. There's no business transaction. It's like an informational site. So they've only posted information on the internet, which is accessible to users in other jurisdictions. So it's like a passive website, right? That only makes information available, and if that's the case, there's no grounds for personal jurisdiction. So if you're just posting information on the, you know, FYI, this is all you want to know about the solar system. That's considered a passive website. There's no business interaction going on, and so there's no personal jurisdiction. The middle ground is where you have an interactive website where users can exchange information with the host computer. So you see the extremes. One, they're clearly doing business and exchanging files, information. There's monetary transactions going. Then you have the other extreme where it's just a passive website that posts information up there for the reader, anybody to see, right? And then you have the middle ground, which is what most attorneys end up arguing before the judge, which is where you have an interactive website where users can exchange the information with the host computer. So in those cases, jurisdiction is determined by examining the level, right, of interactivity and the commercial nature of the exchange of information. So they look at, okay, how much exchange is going on. And again, as attorneys, it's your job to say, oh, this, you know, they're exchanging information every day or on a weekly basis. And the other side says, yeah, they're saying that, but in a, you know, that just started recently. Like in a 2-year period, they only exchanged information regularly for 2 months and then it went dry. And so it's your job to look at the facts and convince the judge that this is a very interactive exchange, you know, website, so as opposed to more informational. So there's not like a clear-cut way. So even for exam purposes, I just care that you know the test that applies and that you can apply the facts to it. It's really not a right or wrong answer with this particular thing. Yes?
So for the middle ground, I didn't get, did you say the personal jurisdiction would be determined by just the amount of exchanges?
Yep.
That's it? Okay, I thought you said there were 2 things that you had to use, but.
All right. So where in this scale does the court say the Pavlovich case belongs, and what's the court's reasoning? Where do they say it belongs? Attorney Walls.
So they put it on the end with the just postings, and then say that because he didn't know that their place of business was in California, that they don't have jurisdiction over him.
Excellent, excellent, and excellent. All right. So we like this. They said, look, there's no evidence in the record suggesting that they targeted the state of California, and no evidence that any California resident even visited the website, downloaded anything from the website. And so, you know, they're like, there's really no evidence of sufficient contacts here, is essentially what they're saying. So Pavlovich's alleged conduct in posting a passive website, the court said, on the internet is not by itself sufficient enough to subject California to personal jurisdiction. Just a passive website, right? Creating a site like placing a product, the court said creating a site is like placing a product in the stream of commerce, may be felt nationwide or even worldwide, but without more, it's not enough to be considered an act where they're purposely availing themselves. So they're acknowledging, yes, with the internet, the way it's set up, when you post information, yeah, potentially can potentially get essentially anywhere in the world. But in an internet scenario, they're saying that's not enough to say that you placed an item, I don't want to say product, in a stream of commerce. Not when you're dealing with an internet situation, okay? And so, how does the court address Attorney Blank, sorry. How does the court address the plaintiff's DVD CCA argument that there's purposeful availment of the benefits of the forum state because Pavlovich knew that posting it would harm not only the licensing entity, but also the motion picture, computer, or technology industries centered in California. So how do they address the plaintiff saying, look, there was purposeful availment because, you know, he knew when he posted this stuff it was going to impact these industries in California. What do they say? I think it's on the 121 second and third paragraph, hopefully. Take your time. You're doing a great job. So how do they address the plaintiff's argument that there is purposeful availment because Pavlovich knew when he posted that information it was going to impact those industries in California? Do you have a co-counsel?
Yeah, I'll defer to,
I thought your co-counsel, who, Hall?
Walls.
Well, sorry.
That's okay. I think it's because even though they knew that it might hurt the industry, they didn't know that it was gonna hurt this particular plaintiff.
Right.
And so that they didn't purposely avail themselves to them.
Excellent, excellent, excellent. And so they also said that the plaintiff in this case is essentially asking the court to adopt a rule that the court should be able to exercise jurisdiction over a defendant because he should have known that his conduct may harm industries with the California plaintiff. And they said that the court says that, you know what, this is not, you're asking us to adopt a very broad interpretation of the effects test, which would essentially eliminate the purposeful availment element. And they said, you know, we're not willing to do that. And they said that finding jurisdiction under the facts of this particular case would subject essentially all intentional tortfeasors whose conduct may harm industries in California to the jurisdiction of California. So the court says that would be too broad of an interpretation of the effects rule. We don't want a situation where there's no purposeful availment and a state can assert jurisdiction over a non-resident defendant. And the policy reasons behind that, it's just, you know, they said this isn't good for businesses, this isn't good, you know, in terms of thinking of it in terms of the fairness prong of the Constitution. You know, again, we don't want California to just be able to assert jurisdiction over pretty much everybody in the United States. We want them to, you know, you need to purposely avail yourself to California. And that's why that purposeful availment prong is so important, because before the court established that criteria, it was very easy. It was much easier to assert personal jurisdiction over a non-resident defendant who has no contacts with the state. And I don't want to be in a position where I have to go and defend myself in Kansas, no offense, Professor Mr. Rothstein. When I don't have any contacts there, I didn't purposely avail myself to the state of Kansas. I don't want to have to travel there back and forth for a lawsuit. So this purposeful availment thing, I personally feel is one of the most important advancements of modern day personal jurisdiction jurisprudence. I think it's really, really important. So the court is saying that a defendant's knowledge of harmful conduct or conduct that may harm industries in the state, are they saying that it's completely irrelevant, Attorney Harper, to the question of whether there's personal jurisdiction? Is the court saying that the defendant's knowledge that the harm may cause, or the conduct may cause harm to a particular industry in the state, are they saying that's just not relevant?
Not necessarily, no.
Okay, what are they saying then? Very good.
They're saying that it's a factor, but it by itself is not sufficient enough.
Excellent. So they're saying no. The court is saying no. We're not saying it's not relevant. It's relevant. You know, that a defendant's conduct, they know that their conduct may potentially harm someone in another state, but they're saying that that knowledge alone, as Attorney Harper said, is not enough to establish purposeful availment, that they're expressly aiming at the forum state as required by the effect state. So they're saying, no, we think it's relevant that they might know, yeah, my conduct may harm someone in another state, but they're saying that alone isn't enough. You still need that purposeful availment prong. And so let's talk briefly about Judge Baxter's dissent in this case. And just tell me, anyone that wants to volunteer, if you agree or disagree with Justice Baxter's dissent. So he completely disagrees with the decision in this case. Specifically, he disagrees with the court's analysis and states that the record indicates that Pavlovich knew that the intended target of his conduct was not an individual person's or business, but he knew that it was entire industries. He knew when he created that anti-copying software that it was going to impact the tech industry. So Justice Baxter is saying he knew what he was doing. And he said the record indicates that Pavlovich knew that at least two of his intended targets, and I'll get your question in just a minute, which would have been, again, the movie industry and the computing industry, were centered in California. So they're like, he knew what industry was going to impact. He knew there, the big hubs were in the state of California, and Justice Baxter is saying this. So he said the record supports the trial court's conclusion that the defendant's actions were expressly aimed in California. Because he knew that when he put that site up, everyone knows the movie industry for the United States is in California. What do you think?
I like the opinion's decision, and then one of the last sentences said Pavlovich may still face the music, just not in California. So they still have, ways to go after them.
Yes.
I see similarities between that and the Arizona case, where it was like Arizona should have jurisdiction of that accident that happened because they have an interest in protecting their highways, just like that. In California, they have an interest in protecting their industry. So
you see a similar parallels with that particular case. Anyone who agrees with Baxter? Just a show of hands. You did, Jessica?
To an extent, and I'll confess that I'm a bit biased because I come from the music world where this is some situations similar to this are very common occurrences with copyright, trademark, because with this sort of anti-copying, this ensures that everybody who worked on the product gets paid. That includes musicians or actors in a movie. When you develop software like this that creates a loophole, that means, like in the music world, for example, it means musicians are not getting paid their royalties, which is unfair to them. So do I agree that in this context, at this particular point in time, that knowledge should have been enough? No, but in a more modern setting, yeah, I think now the dissent would apply a bit more.
I mean, if we're being honest, as Jessica's referencing, it is stealing, right? You're getting materials that you didn't pay for, right? And I feel so bad because she's right, but there's this Robin Hood part of me that feels like they charge so much for this stuff. And I'm still ticked off with the airlines that we still pay money to check our bags. The carry-ons, when they did that because of the gas hikes, well, gas is so low now, it's scary. I'm like scared to say something because I don't want it to go back up. But why are they still charging us? Like, I feel like they're exploiting us, and they've already made plenty of money. Gas is the same. Like, I get mad at, I feel like the airline flights, and I do this because I travel every week, but I feel like the flights should be the same price based on what class you're in. So if you're in, whatever, regular main cabin, this is the price. If you're in Delta Comfort, I think it's called, or Comfort Plus, you pay that price. First class, you pay that price. But it should be a set price. It shouldn't matter if I'm flying during the holiday time. Why are you charging me double for the ticket during the holiday time when gas is the same price? Like, you're flying, and I know from the business people in here, supply and demand, and I get it. But my gosh, I feel like we're totally getting worked. So does anybody agree that we're totally getting screwed with the baggage at least? Thank you.
Oh, yeah.
And I'm like, why won't we fight back? But yeah, I just feel mad. And I do like, so I did the most dishonest thing. I had my luggage last week. So it's a rolling bag. And then I have a, the personal one on top. So I'm only allowed 2 bags. I was like, whatever. I had another tote bag on the back of the thing, and then I put, because it's wintertime, my winter coat, like I'm hanging my coat on the thing. And I pushed it right through. I said, beep, and went on through. I was like, I'm not paying you another $35. So I had 3 bags on the plane. But I can only get away with that in the summer. I mean, in the winter, yes.
TSA gonna take her down.
I will say,
They ain't fucking right now.
talking about this and
Yeah.
kind of both agreeing and yet disagreeing with Ms. Harper is there's the issue of with the Robin Hood on the public domain. There's about 50 million things that should have gone into the public domain roughly 30 years ago. And thanks to Mickey Mouse, we're probably never going to get things that should be public domain into the public domain back because Disney took the public domain, showed the use of it by completely destroying it. And people should be paid, yes. But there comes a point when it's no longer, okay, should they be paid? It is, when do we get our turn to actually touch it and play with it?
That's true. We're the music world, like especially in the classical music world, we're having a lot of that trouble with getting works from composers like Shostakovich, Stravinsky, because those are still protected by copyright and trademark. And depending on what country you're in, it could take years for it to go into the public domain. So you actually have to pay money to just get your hands on like a score. So whenever we play something by those composers, a lot of times we have to rent the parts from a company.
Oh, that's terrible. Yes.
This is kind of going with like the majority argument in this case. I feel like that would open the floodgates though to like, you can't, that would just be ridiculous to have like lawsuits in every single state because everything's online nowadays and without, I don't know what this, I mean, not to like.
I completely agree. Since she hasn't had a chance to speak, and then go ahead.
When you were talking about the sliding scale, I was wondering about Wikipedia, where it would be, because in a way they post information, there's nothing for sale, but then people can go in and edit.
Right. So remember, one of the criteria is if they're exchanging files. So you would just have to try to make the argument that editing is for essentially exchanging information, because you are collaboratively working. There's this interaction going. It's more of an interactive website as opposed to just posting information. But again, the judge is going to make that final. But that's the argument I would make, that it's interactive because it allows the users to edit the contents. Yep. Yes.
Never mind. Actually, I'm gonna hold on to it.
All right. Curiosity question: where are you from originally?
From here.
You are from here. Okay. All right. So we know that the reason we read this Pavlovich case as we move on to our next case is just to remind us and let us know that when assessing minimum contacts in internet cases, that we're going to use that 3-part sliding scale. Anytime it's an internet case, we're going to use that 3-part sliding scale to make the argument that they either do or do not have sufficient contacts with that state, that they have purposely availed themselves. So again, we're looking at if there's doing business over the internet, or is it just a passive website, or somewhere in the middle. Judge makes the final decision. So let's talk about this very important and kind of pain in the neck Nicastro case, okay? Yikes. Facts for Nicastro. Someone, go ahead, facts person.
So, plaintiff Castro was using this metal shearing machine that the entire machinery had manufactured in England.
Okay.
That's where the company is located. The plaintiff filed the liability suit in New Jersey.
Yes.
When the accident occurred, but McIntyre
all the time with interstate commerce, where you have a situation where you want a defendant who's a foreign defendant to come here and defend themselves, right? So we know the accidents he said occurred in New Jersey, but the machine was made in England. Defendant is incorporated in England. So what's the criteria for me to bring someone from England or Switzerland, wherever, a defendant come here and defend themselves? And so a U.S. distributor basically had agreed to sell all of this English defendants' corporations' machines in the U.S. So that's how the product essentially ends up into the stream of commerce, okay? So the issue in this case is whether New Jersey, where they filed the lawsuit, will have personal jurisdiction over this English corporation. So very important. So we know at trial, the plaintiff makes an argument as to why there should be personal jurisdiction in New Jersey, not be personal jurisdiction in New Jersey, sorry. Essentially they say what? Why should there not be personal jurisdiction in New Jersey? Attorney Blank.
Well, they don't have any direct contact with the state, and there's only 4 of the machines in the entire state, so, including the one they issued.
What did they say about conventions? Do you remember?
They attend 4 equipment shows.
No, they only had 4 machines, which is right where you got that number for.
Okay.
But what did they say about the number of annual conventions they attended?
They go to several conventions around the state, but none in New Jersey.
Excellent. All right. So we know they're an independent U.S. company had agreed to sell, as I mentioned, the defendant's machines to the English corporation, but the distributor was not under the defendant's control. So that's one argument. Second, yes, the defendant officials attended annual conventions that were in various states, but none of them were in the state of New Jersey. They've never been there. And as he stated, Attorney Blank, there's only 4 machines, including the one that injured the plaintiff, ended up in New Jersey. That's a very minute amount. 4 machines out of the thousands they're selling in the U.S. So defendant essentially argued that they did not have minimum contacts with the state of New Jersey. Strong argument. Hey, I don't have any contacts. I haven't purposely targeted New Jersey. We've never been to New Jersey, right? Only 4 of our machines ended up there. New Jersey shouldn't have personal jurisdiction over me. So did the New Jersey courts, Attorney Harper, agree with the defendant? Did they say New Jersey does have personal jurisdiction, or New Jersey does not have personal jurisdiction?
The New Jersey Supreme Court concluded that there was jurisdiction.
Excellent. So the New Jersey Supreme Court said, we agree. New Jersey does have personal jurisdiction over the defendant. I kind of feel like they're biased because they're, again, think about the interests of the state. They want to make sure that their residents can litigate harm that occurred to them as a result of an outside entity. But that's just me. That's the human side of law. So we know, yes, New Jersey Supreme Court says that state does have jurisdiction over this English corporation. What was the New Jersey Supreme Court's reasoning for that? Essentially, they relied on the standard in the Asahi case, very controversial case, that courts can exercise personal jurisdiction over a foreign corporation or manufacturer as long as the manufacturer, quote, this is from the Asahi case, knows or reasonably should know that its products are distributed through a nationwide distribution center that might lead to those products being sold in all 50 states, okay? So the New Jersey court concluded that the defendant could be subject to personal jurisdiction even though it did not advertise New Jersey, send goods to the state of New Jersey, or target the state of New Jersey. Because again, they said if they know or should reasonably know that its products are distributed through a nationwide distribution, you should reasonably anticipate that it may end up in one of those 50 states, and you may have to go and defend yourself. I think that's pretty reasonable, right? Maybe not great and fair, but hey, if you want to do nationwide distribution business, the Asahi court saying that comes with, trick of the trade. It comes with the territory. You can't have your cake and eat it too, essentially. So you want to be a nationwide distributor, you need to anticipate that you might be held into a court in one of the 50 states to defend yourself. So the problem with the Asahi case and why law faculty such as myself hate this case, it's a 1987 case. And the Supreme Court in Asahi essentially relies on 3 different interpretations of the holding. 3. That's bad. I need you justices to all decide. You're brilliant. Yes.
Is this the one with the plurality opinion?
Yes.
That explains a lot.
And so it's just like, come on, I need you all to just agree, give us the good letter, black letter law, so we can go and use it in practice. I hate this case. And so this case is considered to be a major disappointment because although the majority agrees that there is no personal jurisdiction over Asahi, they disagree on the reasons why. No, I need the rationale so I can look at the facts of my client's case and see if I have a strong case here. So this is a very crappy case. So again, majority agrees there is no personal jurisdiction. They disagree as to the rationale as to why. In this Asahi case that I don't have you read anymore, there are 2 theories on whether Asahi established relevant contact with California. The first theory is put forth by Justice O'Connor. The second theory is put forth by Justice Brennan. So 2 theories. Neither theory commanded the majority of the court. Each was adopted by 4 justices. As a result, there's no holding on the vital question, which we care about as attorneys, of what constitutes a relevant contact in the stream of commerce fact pattern. That's a big deal. There's so much interstate commerce. Like, I should be able to tell you the black letter law of how you determine a relevant contact or minimum contact in a stream of commerce. Think about how many products, Mattel, toys, Amazon are put into the stream of commerce. Like, are you kidding me? Why is this not settled law? This is bad. Bad. All right. So, and one positive thing is that the 8 justices did agree in Part 2B of the opinion that personal jurisdiction in California would not be fair under the unusual circumstances of the case. I guess I'll take that. So essentially, the holding that California lacks personal jurisdiction over Asahi was based on fairness grounds. They felt since they couldn't agree on the rationale, they basically based it on fairness. I don't like that. That's too subjective. Give me a test. Give me a test. Give me criteria. Give me a framework. Yeah.
Well, this case isn't going to help much either because this case is also a plurality.
Right. But we're going to get to how we're going to be helpful with that. So yes. Problem. So essentially, because the U.S. Supreme Court's jurisprudence on minimum contacts in the stream of commerce context is unclear, when applying the Asahi case, the New Jersey Supreme Court chose between applying, again, Justice O'Connor's test and applying Brennan's test. So let's talk about these 2 theories of how you determine if there's minimum contacts in a stream of commerce situation. Again, where a company, a national distributor, has put a product into the stream of commerce, right? So in Asahi, what was Justice Brennan's theory of what constitutes a meaningful contact by the defendant, either attorney Blank or Walls? What was Justice Brennan's theory of what constitutes a meaningful contact by the defendant in a stream of commerce case? It might be on the 4th paragraph of page 126. I didn't double check my pages. Let's see. Yes. So what was Justice Brennan's theory? 4th paragraph, page 126.
117.
Oh, 117, so it is off. Don't listen to my page number. But since you found it, do you mind?
Oh, you want O'Connor or Brennan?
Did you find it? Brennan's?
I think, isn't there 2 principles of personal jurisdiction and then the U.S., like, overall jurisdiction?
Okay, so did you write down anywhere in your notes, and then I'll get you just a sec, what Brennan's stance was versus O'Connor's?
No.
Okay, so first and most important, you're doing a great job today and you're clearly prepared. Moving forward, whether it's my class or another class, if you see a case where there's not settled law and 2 justices have a different theory, it's really important that you identify what those theories are, because you need it for law practice purposes. So you always, if you see 2 competing theories, you always want to highlight them.
Okay.
Yes, go ahead.
He said that it was based on fairness and foreseeability, the foreseeability that the final product would be marketed in the forum state. Then the possibility of a lawsuit cannot come as a surprise.
Yes, so Brennan, so we're gonna listen carefully because I'm gonna ask a show of hands if you're on Brennan's team or O'Connor's team. I need you to pick one. You can't be in the middle. All right, so Brennan, as she's saying, is basically saying that all you need for a stream of commerce, and I'll make it more simple in a minute, is that the goods get to the state, right, through the stream of commerce, plus awareness that the final product could get into the farm. So essentially what he's saying is that general foreseeability alone is enough to meet minimum contacts. So foreseeability alone is enough to meet minimum contacts. And getting benefits from the sale of goods in a foreign state is enough to meet the fairness test. I like that. Foreseeability alone is enough to meet the minimum contacts. Yeah, it's foreseeable if you're a national distributor that your products are gonna get, into Iowa. And you're receiving benefits from the state of Iowa because if your product gets there, you're receiving monetary benefits from the sale of goods in that state. So again, Brennan says, look, general foreseeability alone is enough for minimum contacts because you're getting the benefit from the sale of the goods in the foreign state. That's enough to meet the fairness test. That's Brennan. That is Brennan. He says it's not too much to impose this burden considering that you're benefiting from that state's residents. He thinks it's fine. But O'Connor says, Brennan, you're cool. I like you as a person, but you're completely wrong. So O'Connor says, no. You need more than foreseeability. So she says foreseeability alone is not enough. O'Connor says you need more than foreseeability. You need specific intent to target or serve the market forum state. Purposeful availment. She's like, you need specific intent to target or serve that state. So O'Connor says, I disagree, you need more than just foreseeability. So we've got Brandon saying, no, foreseeability alone is enough. They're benefiting from the state's residents. That should be enough. O'Connor says, no, that's going to open up Pandora's box. They need to target that state. We don't want these manufacturers being subjected to personal jurisdiction in all 50 states. So, show of hands, who agrees with O'Connor? About half. Okay, so obviously the other half is Brennan. Anyone comfortable telling me why you think O'Connor, the people who just raised their hand, is better than Brennan's? Thank you, yes.
I think that Brennan's theory of foreseeability has problems for me because hindsight is 20/20. So in today's age, I could invent something stupid like a couple years ago, somebody sold a rock on Amazon and it blew up and turned into this big thing.
Yeah.
So
where you can paint your own rock.
Yeah, exactly. So in today, it's really not foreseeable in every situation that the stream of commerce is going to be limited to one area.
Excellent. Yes, and then back. Go ahead.
There's also this principle in law that we can't regulate people's inner thoughts. We can only regulate what they do on the outside. So O'Connor said that it's the defendant's actions, not his expectations, that empower a state's court to subject him to judgment. So that just follows along with that general principle that, we can only regulate what he does, not what he thinks or feels or expects.
Or should foresee.
I was gonna say this.
Really? Who says the opposite? Yes, thank you. Come on, Brennan.
Well, so you still have the fairness prong to satisfy. So if you want to do the O'Connor test, or if you think the Brennan test is bad, you still have to go through fairness. So if it were foreseeable, and you still have to go through that. Also, this really allows for the, I think, unjust result in this case, I really vehemently disagree with O'Connor.
Yes. In the back, yes, ma'am.
I think foreseeability would have to be demonstrated through your actions also. If you are actively advertising somewhere, then it's foreseeable that your product is going to end up there.
Should it be your actions or based on a reasonable person standard, like you said, where a reasonable person think is foreseeable?
But given the circumstances.
Okay. Yes.
Well, when it comes to foreseeability, to me, I'm thinking once they ship the product, that should be foreseeability enough.
That once it enters the stream of commerce.
Yes.
So you are, your foreseeability alone is not enough. You're Brennan.
Mm-hmm.
Wow. Yes, ma'am.
From Brennan's perspective, which I agree with, I was thinking if you have a faulty product or something in just tort suits, it would be hard to allow the plaintiff to be made whole if you can't sue them, and they're again a large corporation, so they should know these things when they're selling goods across the state.
Yes, sir.
So I agree with what she said, in that it's hard to draw a line and cut off, where foreseeability is. Once you let it out, who knows what it's gonna do. And then with the fairness thing, didn't we bring fairness in to the defendant, because it's hard to travel? So now everybody's you fly every week, so you know how easy it is to get somewhere.
It's not easy. Flights cost money.
That's good.
Because it's expensive. Yes.
I feel, not listening to everybody now, I'm feeling like one of the big problems with this IA case is that there's one big factor that everybody seems to ignore, and that's the size of the corporation. It seems like one theory would work best for larger corporations for them to avoid personal jurisdiction, but then the other one would work better for smaller
For mom and
corporations.
pop. So what do we do about this split? Yikes!
Let's go with Ginsburg.
Oh, stop. All right, so another reason, and I will make sure it's clear what we do for law and class purposes when I'm done, but another thing that, criticism rather, of the Nicastro case is that because the Supreme Court opinion was divided, if you look at the very first sentence of the case, you can see how many justices joined in the plurality, which is 4, which is a lot. So if you count up the votes of plurality with the votes of concurring justices in this case, you can see that the justices were essentially divided 4, 2, and 3, right? With the plurality and the 2 concurring justices agreeing that there is no jurisdiction, but not on why they reached a result. And so if you look at the plurality's opinion, which was written by Justice Kennedy, and then we'll talk about the concurring opinions. So what's the holding and reasoning of the plurality's opinion? Writing for the plurality, Justice Kennedy wants to make purposeful availment of the forum state the key to jurisdiction, which supports what some of you were saying. Finding that McIntyre had not reached out to New Jersey, there was no jurisdiction, meaning bottom line. For Justice Kennedy and the justices who joined him, they say that the relevant question is whether the defendant has followed a course of conduct, again, conduct directed at the society or individuals in the forum state. Justice Kennedy and the plurality, sorry about that, said again, foreseeability alone, not enough. They essentially reject Justice Brennan's concurring opinion and support, or rather accept O'Connor's. But then we have the concurring opinion, which is joined by Justice Breyer and Justice Alito. And the point they're trying to make is that they said, look, we agree with the pluralities that there is no jurisdiction over the defendant in this case. Again, we disagree with the rationale. So Justice Breyer and Alito refused to endorse the rationale because they said they found that the case, which involves a single sale of a product in the forum state, was easily decided on the basis of precedent, and that McIntyre's contacts were just too slim to justify jurisdiction. They didn't feel like they had enough of a presence in the state of New Jersey. Remember, only 4 of their machines got to the state of New Jersey. Breyer and Alito did not think it's necessary to even resolve the Asahi split. I disagreed. Tell us which one to adopt, Brennan or O'Connor. But Justice Breyer and Alito said, look, we don't have to resolve the Asahi split. There's no opinion that suggests that a more flexible standard may be necessary, particularly when dealing with modern issues of commerce, such as the internet. They insist that Nicastro is not the proper vehicle for making this determination. This is not the case we want to use to determine the split that we see in O'Connor versus Brennan's stance. So they think it's basically not wise to adopt this broad rule without considering modern day consequences. The dissent, we have Justice Ginsburg, Sotomayor, I said her name wrong, I apologize, and Kagan. So the dissent says, look, we disagree with all of you people. You all got it wrong, right? The dissent says, they didn't discuss the stream of commerce at all, but they essentially endorsed Justice Brennan, right? Standard from Asahi, and they said, we just need to focus on fairness and reasonableness, and that solves our problem. They say that the U.S. plaintiffs at a disadvantage when compared to the European plaintiffs or individual because under European law, there would be personal jurisdiction. They said, so we don't even want to consider that. Let's just consider, is it fair, is it reasonable, based on the facts, and let the court make a decision. So we don't need to even consider foreseeability and all that stuff. Let's consider the travel costs for that, for that European, foreign corporation to come. Let's consider, the inconvenience. Let's consider the state's interest. Let's consider the foreign corporation's interest. Let's just look at the unique facts of each case and decide if it's fair or reasonable. And we don't need to go back and forth. We don't even need to address the Asahi split. And so the takeaway from this case is basically that because there's no majority in this case, the court still has not established a clear standard of what minimum context is necessary for a stream of commerce context. Like, how do you determine minimum context in a stream of commerce context? It is not clear, unfortunately. So therefore, it means for exam purposes, when you see a stream of commerce question, you'll utilize both the pluralities test and essentially Justice O'Connor's test from Asahi. So you're going to say, if this was, I will ask you on the exam, if you were stating the outcome of this case based on Justice Brennan's stance, what's the outcome? And you'll be like, oh, well, foreseeability, okay, boom. Or I'll say, if you were assessing this fact pattern from Justice O'Connor's stance, what is the outcome? So I'll tell you which one, because there's nothing else I can do because it's not settled law. For practice purposes, typically certain jurisdictions will be more likely or favorable towards Brennan versus O'Connor. So you need to look at that jurisdiction, the case law, recent case law with similar case fact patterns, and say, oh, okay, the justices in the Seventh Circuit really tend to adopt Brennan's stance. So you're going to pose your argument based on Brennan's stance in the most favorable light of your client. That also kind of pushes you to do forum shopping. So I'd be like, well, if I have a choice where I can technically file in the Western District of Kentucky or the Northern District of Ohio, one has adopted O'Connor's stance, the other has adopted Brennan's. Well, Brennan's is going to be more favorable to my client's facts pattern, so I'm going to say, tell my client we need to file in Ohio, Northern District Court. But you see how the strategy involved, and I mean, you can literally, and I'm going to bring in, I hope Rudy Cooper is available, because he was like my civil procedure rock star student. And he's out doing amazing stuff, but he always, when I run into him, he brags how he's like, I out-lawyered, senior attorneys because I beat them on procedure. Meaning we had a weak case, but I beat them on procedure. So a lot of times when you have too many cases and you're overwhelmed, a smaller firm, you miss deadlines, so to respond, so someone has filed a motion to dismiss and you don't file your response in time, default judgment, the others, so you can win cases just on strategy and procedure, even if you have a weak case. So this Rudy, it's better when you hear it from your own peer because he's got great examples, but I mean, he literally wins cases on procedure. It's great. So it's really important. I'm not saying that because I teach it. It honestly really is. All right. So that would be our Nicastro case. So we will start our next class with the Goodyear case. Any questions before you close your books about class today at all? Everybody's cool with Brennan and O'Connor? Yes.
What I got out of the dissent was that the British manufacturer targeted the national market, and New Jersey is a part of the nation, and so that's fine. Because I supported O'Connor, but I also support the dissent in this case. Is that an okay view for me to have, or should I shift?
No, it is an okay view for you to have, because yes, so you don't have to shift.
All right.
And even for practice purposes, you don't have to shift, you just gotta write that same compelling argument in your brief. So you are accurate in your legal analysis.
Got it.
Okay. Anybody else? Yes.
I'm just gonna say, Neil, they were the top producer of scrap metals, so if you're they were in, you know what I mean?
Reasonability plus Ryan.
Yeah. Okay, I just wanted to add that.
Try to convince them. All right,
Yeah.
I'll see you all next Monday. Yes.
Oh, really? I'm gonna have to go back to my class.
Yeah.
Why?
When do you go out of class?
I don't mean that sarcastically.
While I'm sitting.
I'm gonna go to we have contract. We still have like 30, 40 minutes. Do we?
I meant that in like.
Oh, yeah,
it was what was
10:50. Oh, I'm
Yeah, like being
gonna.
the top producer of scrap metal, like
Oh,
if you're,
yeah.
if you're